Happy holidays to you. It's a great day here at Elville and Associates, and welcome to our webinar series. Today's topic is Achieving Perfection for Your Legacy, Intentionalism in Estate Planning, presented by Elville and Associates Managing Principal and Lead Attorney Stephen Elville. He'll be joining us in just a moment. Had to reboot his computer. My name is Jeff Stauffer, Community Relations Director here at Elville and Associates, and I'll be your moderator for today. You're at the right place for high-level legal education. We encourage your general questions today, so please note them in the chat or question section on your screen, and we will pause periodically to address them as always. Your questions add value and help others learn, so don't be shy in posing your questions at any time. You received the presentation slides by email from me yesterday. Steve will be referencing to take notes if you wish. These materials are also available in the section marked handouts in the panel on your screen to download at this time. For our professionals on today's webinar, a warm welcome to you as well. 1.5 continuing education hours are available for most everyone in attendance. If you'd like to submit an ID number and your accreditation for me to provide a certificate of attendance or submit your information to the CFP Board of Standards, please send that information to me today if I don't have it already. Everyone will also receive a post-webinar feedback email right after the presentation, and we ask that you please take just a couple minutes to fill out this very brief survey to offer us your feedback about the presentation, and we read and value every comment that you have to share with us. As I mentioned before, we have several new presentations coming up in early January and February of 2024 that are a direct result of your survey comments, so thank you for your attention to that. In this season of giving, give the gift of planning and security to yourself. Here at Elville and Associates, we always want to be a resource to you. If you have planning needs to address old documents that need to be reviewed or another matter, consider a consultation. Use today's education as a jumping off point to get your planning started. Consultations are always by far the most ideal way to get your specific questions answered. Have Steve understand your individual situation and offer solutions and a path forward for you. So relax today, listen, and enjoy your presentation. 1 second. Sorry about that. That was Steve. He's going back to his office to set up. It seems like things are running a bit slow in the conference room today. So sorry about that. So while Steve's setting up, and give the firm and Steve a brief introduction as always. So let me click on my screen here. You should be able to see my screen. Elville and Associates here, founded in 2010 in Columbia by Stephen Elville. We have several different practice areas that we focus on here at the firm, including estate and special needs planning, elder law and elder care planning, estate and trust administration, business law and succession planning, guardianship and litigation, tax planning, and asset protection. We have 9 attorneys, 12 staff members, and 5 locations, and Steve and I are coming to you live from the Columbia Gateway Community location today. Our mission, as it always has been and always will be, is to provide practical solutions to our clients' needs through counseling, client education, and superior legal technical knowledge. And we focus on education a lot here at Elville and Associates every day, and we do that in several ways: through our planning processes with our clients, through educational webinars and workshops in the communities that we serve each year, and by way of our accredited client care program. We're one of only 2 firms in Maryland to have a client care program accredited by the Client Care Academy in Boston. We have several new members that are signing up as membership starts on a calendar year. So now is a great time to learn about the CCP, and I work on that on a yearly basis. So if you're interested in learning more about that, feel free to reach out to me. I'd love to talk more about it with you. A little bit about Steve. His work as an attorney for the past 23 years, to be exact, has been centered in elder law, special needs planning, and estate planning, with an emphasis in the areas of tax planning and asset protection. A member of many different national membership organizations, including just a few: the National Academy of Elder Law Attorneys, the Academy of Special Needs Planners, and the National Network of Estate Planning Attorneys. He works to bring peace of mind to clients by offering solutions to the needs through counseling, client education, and the use of leading-edge legal technical knowledge. Steve is a very seasoned speaker, if you haven't heard him present before, offering many webinars, workshops for businesses and their employees, conferences, and continuing education events each year. Steve has been named to the Maryland Super Lawyers list for an 8th time in 2023 and a 7th consecutive year. He also had a feature story written about him in the National Super Lawyers magazine about the Elville Center for the Creative Arts, which is our firm's charitable organization he founded in 2014, and I'm very fortunate to be the executive director of. If you look to learn about our work and how we work to make a musical difference in the lives of children each day, please feel free to reach out to me. I would love to share our story with you when we have just a bit more time. But today we have another topic to talk about. I'm going to see if Steve is on yet.
Jeff, I am here.
All right, well, isn't that something? Timing is everything, Steve.
Thank you.
Couldn't have timed that any better. It's like we planned that out. I guess after working together for 10 years, kind of synergy going here.
Well, what my thoughts are, Jeff, is that the internet was acting up because the large internet companies are trying to stop our presentation and force people to go shop it. So
I think that's a realistic thought.
All right, well, I'm here and we're ready to get started.
Gonna make you the presenter here, Steve.
Thank you. All
right,
Jeff,
thank you like your thoughts for a minute, but that's not the case. You're already in good shape.
Thank you very much, Jeff. And I'm now going to get our slide presentation up. Thank you, everyone, as Jeff and I are getting past some technical difficulties here on a Friday morning. So happy Friday to you, December 8th, 2023. And we are in the full holiday swing here. We did a webinar 2 days ago. And for those of you who were not on that webinar, Jeff tells me that his holiday shopping is already done and was actually done 2 months ago. So I don't know if I can boast about that kind of efficiency, but we're all excited about the holidays and we hope you are too. And thank you for taking your valuable time on a Friday morning to spend with us. And I hope you have a wonderful weekend planned ahead and a wonderful day ahead. And as we get into this topic about how to be intentional in estate planning, I was thinking about this topic years ago and I thought, you know, what we need to do in estate planning as lawyers and as financial advisors and CPAs and life insurance professionals and others is we really need to support clients to achieve as much perfection as possible in their planning. And yet, striving for perfection is something that normally we would say, gosh, that person is a perfectionist, or sometimes people pursue certain endeavors and they're striving for perfection so much that they actually shoot themselves in the foot, so to speak, and they can't get their project done. For example, writers are notorious for not really getting started on their writing projects because they're trying to achieve perfection. And the idea, once you get past all of the roadblocks, for example, of writing or painting or whatever other project you're going to do, is to just get it on paper, just get it started and not strive for perfection, but just get it done. And yet, in another sense, when we think about estate planning and things that are so very important to our lives and to our legacies, we want to strive for perfection, but not to the extent that we don't get started, or not to the extent that we get started, but we are so hard on ourselves that we don't finish, or we think it has to be just achieving some extreme level of perfection. So somewhere in the middle there, we want to strive. We want to work very hard to keep up our planning because most people never update their planning. Most people never maintain their planning, and that's assuming they have a plan at all. So we want to find some happy medium between achieving perfection, which we're going to talk about today, and the effort it takes just to make sure that we are striving. So I couldn't think of a better analogy. My son, Brad, tonight is running a 60-mile race. Many of you may have relatives, or maybe you yourself do this kind of thing. He's running a 60-mile run tonight, starting at midnight down in Virginia, and they're going to run all night, and he'll probably finish this long race about 4 or 5 o'clock on Saturday afternoon. So yes, he is an unbelievable athlete, and many other people work towards these kinds of long distance runs. And then he was reminding me, he said, well, Dad, if you think that's really something, he said, I'm thinking about this 240-mile race out west. And many of you know what I'm talking about, these ultra marathon races. So, he was telling me about that race, and I thought, wow, and I listened to a couple of books by runners who run those long distance races. And what I learned was they run much of those races, and then they, walk or, use, I guess, ski poles, and they kind of walk, run a lot of that distance. And sometimes they stop and sleep for 2 or 3 hours, I guess. But the idea there is that they are really striving forward. And that's what I think we're really talking about when we're talking about estate planning, getting it in place, uh, maintaining that estate planning. It's an uphill climb. It's an uphill climb to make sure that at the time of our deaths, which we don't know when that's going to be, and we don't know how long from now it's going to be, we don't know where we're going to be, but it's that uphill climb, that long distance race, whether it's 60 miles or 240 miles in our imagination, it's the continual striving for perfection, and not, of course, we want to achieve the perfection as well, but not to the extent of making it an obstacle. So hopefully I've given you some framework of what we're going to talk about today. And what we're going to talk about today is not technical. This is non-technical stuff. Now, it is true that in certain aspects of estate planning, we have to achieve a technical perfection as well. But I want you just to assume that in today's world, getting that technical aspect done is kind of a given. If you have an attorney that you can partner with that is going to help you get that basic technical stuff in place, you shouldn't have to worry about that. You are being advised by a professional or professionals. Okay, you don't need to worry about that so much. Yes, that is something to be concerned about, but you don't have to focus on that. What I want you to focus on is just making the effort and understanding that if you make that effort, you will get to the finish line. It does not have to be perfect, although we are striving for perfection, obviously. So it's the effort, it's the ongoing maintenance and updating of estate plans that we're talking about. Now, having said all that and gotten past the technical difficulties, this is a very high-level presentation. It's not meant as legal advice, although we can enter into a legal relationship as an attorney-client and having that confidentiality. So let's talk about today's presentation, why being intentional matters in estate planning. Understanding the risks. Now, we just talked about one of the risks. One of the risks is trying to be too perfect. So we don't want that, but we want that continuous striving. Why knowing what you want out of estate planning matters. Estate planning should be goal-driven, goal-driven. Avoiding failure in estate planning, obviously, that's what we want to do. And we're going to talk about maintenance and updating, which I talked about just a second ago, and the importance of partnership. Now, let's get very fundamental. And I'm looking at Webster's online dictionary a while back, looking at the April 2020 definition of intentional. So obviously here we have bullet points, done by intention, something that is done by intention or design. Okay, I could accept that. I thought that was very fundamental. But the second part of the definition really blew me away, because I've always thought that you can be as intentional as you want, but you have to have some kind of process. You have to be able to engage with your professionals, and your professionals have to be able to engage with you, and that's what we call partnership. And when you have that partnership, you have something that will actually work for both sides. But a partnership alone is not going to be good unless there is a process. So that's what we want to talk about here, is something that is done by design, something with intention, but it has an external reference. And that's, to me, what the process is. So you need partnership, you need process, okay? And without a process, things can go awry, things can go missing. I was listening to something the other day about emergency room doctors or pilots or anything in a high-risk profession, and they were talking about using checklists, okay? So checklists can avoid a lot of failure. Process can avoid failure. Now, synonyms include, of course, being conscious, deliberate, knowing, and purposeful. How could we better describe what it takes to do good estate planning, except to say we have to be conscious, deliberate, intentional, knowing, and purposeful? And of course, what's really interesting is to say, well, what's the antonym there? The unintentional or non-deliberate act. So can you imagine having an unintentional estate plan? Yet many, many people have an unintentional estate plan, something that does not work the way they envisioned because they were not as intentional as they should have been. So again, we want an intentional estate plan as one that is designed and done with conscious and deliberate intention with reference to an external process. So getting to the more fundamental parts of the presentation here, this commitment is 100% within your control. You know, that person that goes on that 240-mile race, and there are audiobooks and other things that you could reference about these races and the commitment that it takes for someone to be able to finish a race like that. The commitment of my son to run all night tonight with his headlamp on. I don't know how he does it. He is a great runner, but he runs maybe a 15-minute mile when he's running this 60-mile race. Not super fast, you know, they are going slow. But that commitment to do that is just something that boggles my mind. So we want to have that commitment, and we want to be willing to participate in an organized process. So for example, that is something that is not entirely within your control. The commitment part is in your control, but the participation in an organized process is not 100% in your control unless you choose to work with an organization. And for example, Elville and Associates has this process. We have a very defined estate planning process, but we also have a future updating and maintenance process, which is the client care program. So that's not entirely in your control unless you overtly try to make sure you're partnering with a firm that does reach out and say, yes, we want to participate with you in this partnership relationship. So for those of you who know me or those who've heard of me, I'm sometimes intentionally redundant, so please bear with me as we get through these first several slides. Randomness really is what we're trying to avoid. How many of us have experienced some kind of random event or something that we felt was random? Well, that can be very innocuous, or it can be very dangerous to experience a random event. So we want to eliminate randomness from our planning. And, you know, the estate planning world looks like a very random place, just like any other endeavor. Like I'm going to get replacement windows, or I'm going to get a new roof. You know, if you're not directed in some path to the professionals that you need to deal with, there is an element of randomness. So you have to do your due diligence, and you have to say, hey, I'm committed, but am I working with a firm or a professional organization that is committed to the thing I'm committed to? And that's what I want you to be thinking about, to eliminate randomness. Okay, so estate planning is an idea. Okay, it's a process, it's a lifetime endeavor. It's that 240-mile race, for example, versus a transaction. Some of you on this webinar have done estate planning before, and you've been experienced, or you have experienced a transaction. You know what you experienced more than I do. You know what I'm talking about. If you ever got a will or trust or other estate planning documents, and you were just simply given those documents without much explanation, and it was very quick, and then you never heard from that organization again, you experienced a transaction. We don't want that. We want this life process, and not a transaction. So there's a statistical chance that your estate plan will collapse. That's pretty harsh to say that, but it's true. We will have an estate plan that won't work. It may not function because of the drafting. It may not function because of a lack of updating because of changes in the laws. It may not function because assets are improperly aligned. You may have all the best intentions in the world, but you may be working with a financial advisor who could be wonderful, but they maybe advised you to title assets. Titling assets is arguably one of the most important things in estate planning. They may have advised you to title assets in a way that caused failure. Those assets did not flow the way you wanted. Laws changed and technical things changed and you never updated them. Family health issues changed. People moved and you didn't update the addresses and phone numbers and emails of people. So we want an intentional plan, but not an unintentional plan. Again, I'm being redundant. You have to have a commitment to the process, arguably, or you will not have much chance of success. Given the pace of change in the world, given the pace of change of the laws, the politics in the world, what's happening in our country, without this contention, you may not have much of a chance for success, except to be lucky. And we don't want that. We want to eliminate that randomness. So we want to understand these risks. Again, a random beginning, improper incapacity planning. So incapacity planning is arguably one of the most, I know I'm saying several things are the most important thing, but incapacity planning could arguably be the most important thing other than the titling of assets. How many of you would guess what the most important thing in estate planning is from an attorney's point of view? If you looked at all the estate planning documents, you looked at all of them, wills, trusts, assignments, you looked at advanced medical directives, powers of attorney, you looked at agreements of all kinds, prenuptial agreements, other agreements. Which one, from an attorney's point of view, would you say is the most important document? I'm going to give you about 30 seconds to think about that. Which document in estate planning, from an attorney's point of view, is the most important document? All right, in the interest of time, I'll just say, let's keep going. Well, personally to you, there might be other documents or other issues that are more important, but from an attorney's point of view, the financial powers of attorney are the most important documents in estate planning because they provide the foundation for incapacity planning and flexibility under other circumstances that are unfortunate, such as our incapacity. So improper incapacity planning is one of the risks in estate planning. People are living a long time. Those of you who have been to Elville and Associates know we have had people as old as 105 in our conference room. So don't take this lightly. Incapacity planning is arguably the most powerful thing you can do to turbocharge your estate planning and make it work over the long run. Word processing, entering into documents. Now, I said you could probably take a lot of the modern documents today that firms like ours use as pretty technically sound, but there's a lot of word processing documents out there that are not well thought through. They're not leading edge. So that's a little bit of a risk. We talked about process. So if there's no process, there's risk. If there's no partnership, there's risk. If there's no counsel or advice other than basically a transaction, there's risk. If there's no collaborative team, if you do not have an estate planning attorney, a financial advisory firm that's helping you or advising you, if you do not have a CPA or tax preparer that you can rely on, if you don't have a life insurance professional, that is a risk in my opinion, although there are exceptions. We want to see you have this collaborative team. And if you don't have that, we want to help you get that in place. No updating of documents. Again, I'm preaching to the choir here. Many of you are on this webinar because you are committed to this, but this is just something to remember because many of these items are counterintuitive to the way we normally think in our regular lives. So there could be another risk, an attorney who lacks experience in estate planning, but you're referred to that person and you're going to get the result of that lack of experience. Again, a transactional process is a risk. No alignment of assets. You should not be dealing with an estate planning firm that does not help you align your assets with your estate plan. Remember that every basic estate plan has two phases, whether it's wills or trusts. The first phase is the design phase and creation phase. The second phase is asset alignment, making sure beneficiary designations or retitling is in coordination with the entire plan. One of the big issues we see today are people who plan a certain way, but they have their assets with a financial advisor titled in a different way. And those assets can go in a different direction, contrary or not in total coordination with the estate plan. The uninformed client, the person who's not getting updates, the person who is not being in partnership, that's a risk. Weak or inadequate documents, we talked about that. Lack of scope of the overall plan. I've worked with many attorneys who were wonderful intellectuals, but they did not have the willingness to counsel people on the total scope of the total plan. And that could be a tax scope, it could be a long-term care scope, it could be other scope or asset protection. So we have to keep in mind that we want to get comprehensive advice because we're living in a dynamic world. Again, we talked about incapacity, marital planning. Many of you are married, many of you are not. Those of you who are married, you're going to want to know what the options are with marital planning about how we leave assets to each other, what are the risks when we leave assets to each other or engage in a remarriage. Those types of things are risks. Asset protection is a risk. Everything, by the way, going back to the fundamentals, is goal driven. So you may be a person who does not care about attaining asset protection in your planning for your beneficiaries or for yourself in some advanced planning cases. So, but asset protection for those of you who are interested in that is a risk, and you want to make sure you do it as well as possible. Although asset protection is not a 100% bulletproof endeavor. Tax implications and how things happen in the world, about how assets are left. For example, someone could be very charitably minded. We were just speaking to someone this morning who is helping his organization do philanthropy. Some well-intentioned person could want to give an IRA to charity where it will be tax-free. But let's say the advice was to leave the IRA through a revocable trust. Well, if that's done properly, it might work. If it's improper, the IRA is going to be taxed before it even gets to charity, and that would blow up the plan. So there are risks in understanding tax implications. Elder law, making sure that the estate planning element is also being discussed at least in the scope of what the elder law possibilities are, the risks in elder law for long-term care in the future. Special needs planning, making sure that we're accounting for the possibility of someone being disabled or dealing with a situation where someone is already disabled and needs special needs planning, and making sure that's done properly. There's a lot of improper special needs planning that is done. And now in the world, the new Maryland laws that are in place, we can do nice estate planning for special needs between spouses, which used to be more difficult to do. Healthcare decision-making is a risk. Should our loved one be able to rely on their agents to understand Maryland healthcare decision-making? Should our loved ones who are disabled have a supported decision-making agreement versus a guardianship? Strength and qualifications of our fiduciaries. Nothing could be more important today than trustee selection. Nothing could be more important than who is going to be your agent. Who's going to be handling your affairs if you're incapacitated? Who is going to administer your trust or estate? These selections of fiduciaries and successor fiduciaries is a risk, and we have to understand that. Storage access and access to digital assets. This is somewhat of a risk because we could cause inefficiency in our planning. We could cause bumps in the road for our fiduciaries that are not able to access our assets without a lot of difficulty, so we don't want that. And one of the more intangible kinds of risks is not building in the proper flexibility into the documents. Now, this is going to matter as far as the degree of flexibility on the risk tolerance of the person, the family members of the person who's doing planning, but designing flexibility is something that is going to minimize risks in the future, as long as it's appropriate for this particular person. So as I've mentioned a few times, with intentional redundancy, all estate planning is goal driven. Estate planning takes commitment, estate planning takes partnership. Estate planning requires a level of endurance. Thus, my analogy to the 60-mile race tonight for my son and the 240-mile race that he would aspire to someday. And on some level, I'm going to now shift gears on you here in this last bullet point. Estate planning is driven by your love for your legacy, your family, your grandchildren, if you have children and grandchildren, your nieces and nephews, your love for your charitable organization. My belief is that you are driven by love on some level to do your estate planning. Now, Jeff, I'm going to stop for just a second. I don't think we have any questions, but I just want to make sure no one's having any technical difficulties and we're good to go.
Thanks, Steve. We're in good shape. No questions as of yet.
Very good. Thank you, everyone, for your time and attention. We're going to keep going. So we want to begin with the process in mind and the end in mind. The end of the process is an estate plan that is designed properly and the assets are funded and aligned properly. When we have those two things, we have an estate plan that's going to work, okay? And we want, again, to be in partnership. If you're working with an attorney, that should be a partnership relationship where there's what? Education, legal, technical solutions that are leading edge, funding and alignment, okay? If you're dealing with an estate planning firm or you have dealt with one that does not assist you, they do not have a funding and alignment coordinator, they're basically throwing the ball back into your court and saying your responsibility is to fund your own estate plan, especially if you have a revocable trust. Well, that's fine, as long as you understand that that is coming from a position that the American Bar Association says that attorneys have no obligation to help their clients fund their estate plans, that is beyond the scope of the representation, and that they have no legal or ethical obligation to do that. Well, that's all good and well, except that's not going to lead to many people having the proper funding of their estate plans. So you want your law firm to make best efforts to help you and your financial advisor work together to get your estate plan funded. The maintenance and updating program, you want to make sure that your law firm offers that and that you're taking advantage of that. At Elville and Associates, for example, we went to the Client Care Academy in Boston, and our friend Vincent, I'm forgetting his last name, Jeff. I wanted to say Bonicelli, but it's Bonazzoli, excuse me. It's Friday morning and I forgot that. So our good friend Vincent, he helped us design a client care program, and we're proud to say we're one of the only law firms in the state of Maryland that has one. And we actually take it very seriously. We have ongoing events, we have a social event, and what we're trying to do is one thing. We're trying to build partnership, we're trying to educate the fiduciaries, meaning the family members of our members, and we're also trying to make sure that they have the opportunity to update on a consistent basis and receive continuing legal education. And then you're going to want to deal with a law firm that has a long-term succession plan. You want to make sure that, because estate planning lawyers don't live forever, estate planning firms and firms all across this country are in transition. You want to make sure your children and fiduciaries know where the resources are, and that those resources, or in some form or fashion, are going to be there for them when you are no longer here. As I just mentioned, we have an accredited client care program. The idea here is to encourage client participation. We give our clients 2 discounted hours of attorney time per year, 3 educational events and a social event, and documents are reviewed on an annual and biannual basis. All of these features are wonderful, but we find that the real reason that clients join our client care program is because they want to know that there are changes in the laws, that they will be updated and notified. That's the big thing. And they want to know that there is a path to be able to update their planning on a consistent basis. And then, in my opinion, the third thing that is important to our client care members is that they can have the opportunity to make sure their children and fiduciaries or their other beneficiaries are educated and know where the resources are. So in this process of maintenance and updating, we are collaborating with financial advisors. We are collaborating with insurance professionals. We're collaborating with CPAs. When I was a young lawyer, this philosophy of collaboration wasn't so prolific. And let's say that I quickly learned that we should not, as lawyers, be in silos. We want to collaborate with the outside world, with all of our advisory team members. But one of the biggest things we're going to talk about here before we get through this presentation today is it's not good enough just to have this advisory team. We want that advisory team to act and think together. We want them to communicate together. This is a very high bar. We want them to communicate on your behalf, and we're going to get into more of that. So examples are recent changes in the laws where we need to update documents, we need to educate people, we need to make sure our clients are aware. The Secure Act in 2020 has changed a couple of times, probably will change again. The augmented estate or new spousal elective share laws, the 2021 scare about the estate and gift tax proposals, the income tax proposals, COVID-19, all of the changes that we're seeing in the world and now through changes in the laws affecting planning itself. Another recent example is Maryland's new decanting law that just happened. Another example is a year ago, the supported decision-making law. So another example this past year was changes in the intestacy laws. What happens if certain people do not have wills? So we're going to talk about all of these things in updating and maintenance. All right, now we are covering a lot of ground. We're covering a lot of fundamentals. Now I'm going to drill down into what we might argue is one of the best ways to avoid failure, one of the best ways to attain perfection. In other words, all of those things we've talked about, we have to have commitment, we have to have partnership, we want to have collaboration. But now when you're talking about that collaboration and you're talking about an advisory team, and for those of you who are making notes, again, this is your attorney, your financial advisor, your CPA, and perhaps your life insurance professional. And in some cases in elder law, we're going to include an advocate or a life care manager. So let's talk about the good things about this. If you have an advisory team, I want to give you a gold star this morning. Jeff and I want to give you a gold star because you are where you need to be. But now we're going to test you and see if your advisory team is functioning the way it should. And we realize, again, we are setting a very high bar here this morning, so take that into consideration. But remember, we are taking that 240-mile journey. We are walking uphill with ski poles. We are trying to strive for perfection. Now, for those of you who do not have an advisory team, let's stop right now and say, we want to, I guess, challenge you in a way to consider getting an advisory team in place. Make sure you ask if you need to help us help you to have a team in place. Let us know that you need a team. Let us know that you need referrals. Let us know that you would like to interview people, and we will send you a list of financial advisors that may be appropriate for you, and you can interview and we can help you get an advisory team in place. So regardless of whether you have one now and you're happy with them, or whether you're not happy with them, or you don't have a complete advisory team, maybe you have no advisors, maybe you have one or two, but you need to round out the team. This is going to be applicable to you. So let's assume that you have an advisory team. These are the good things about that team, okay? You've got that team in place, obviously, that's a good thing. The team is competent, okay? The team is competent to serve you. Now, it's very difficult for a layperson to know that their team is competent, but you would assume that there's competency. So what I would say is your team members should know that if they're dealing with one of the team members who they don't feel is competent, they need to get that person up to speed. And the only way that's going to happen is through communication. So that's the next bullet point. Your team communicates. Now, this is a very high bar. Go ahead and test yourself now. There's been a meeting of the team members and they know one another. That is not something that happens every day. So I want you to think about that. This could affect your ability to have a perfection in your estate planning. The assets have been reviewed and evaluated by the team together. Now, this doesn't have to be an hour-and-a-half meeting. This could be a 20-minute meeting, but your team should be talking about the nature of your assets. I can't tell you how many times, including just a recent couple of cases, where clients who were advised but never came back and participated in the maintenance program, or they were clients from 20 years ago, they pass away and their assets are not aligned properly, and the team was not talking. This can affect the perfection that you're trying to achieve. The team knows your family members and has been part of a family meeting. Now, how many of you have done estate planning where you have had a family meeting as part of the planning? Probably not very many of you. We do that here at Elville and Associates, and we want to invite you to have your family members come to that family meeting. That's the whole purpose. Here, we're talking about going above and beyond that. We're talking about your team knowing your family members and having that knowledge base and having that those touch points for your family. The team has collaborated and agrees on the various aspects of your planning. Now, this is relative, okay? We're not saying here that the lawyer shouldn't stay in their lane and the CPA shouldn't stay in their lane and the advisor shouldn't stay in their lane. We're just saying there should be some at least consensus that everybody understands is on the same page. I had the joy the other day of having a team call for a very important client of ours, and I felt very good about it, that their CPAs and lawyers and financial and tax advisors were all in harmony about what was happening with the client. And that leads me to the last bullet point here. You have the assurance that the team will continue to collaborate. You have this assurance that they are collaborating, but you have the assurance that they will continue to collaborate in the future when you are no longer living. And what? Take care of your survivors. And that's what we want. And the good news, I see some wonderful examples of that in the last couple of years as we ourselves are challenging ourselves and our advisor collaboration referral sources and friends to raise the bar on the level of taking care of people and giving them the assurance they need. But all this to say, this is the road that you're on. This is that uphill climb. This is that 240-mile race to make sure that you are striving, but that you're surrounded by a team that's striving to support you. Now, the bad, let's talk about the bad. You have no advisory team in place, or you have one of the team members in place, but not others. So you might have an attorney, but no financial advisor or CPA. And let's say your team, whether you're aware of it or not, is lacking competence to serve you at the highest levels. That's a very difficult thing to root out, but you should make sure that you're honest with your team members. I want to make sure that all my team members are competent, and that if they're not, that someone's going to let me know. And hopefully that kind of weakness would be revealed. The team doesn't communicate. There's been no meeting of the team with your family. There's been no meeting of the team themselves for 15 or 20 minutes. And they do not know one another. I cannot tell you how many times this happens. This happens because of life circumstances or randomness about how the team came together when you, let's say, found your estate planning attorney or other advisor where the connections got made. So it's the responsibility is yours to make sure that you are so committed and you're seeking out that partnership. But once you are as part of that partnership, you're doing your very best to say, it is not okay for me to have a team unless I am assured that my team is talking to one another and I have proof positive of that. So we're going to continue the testing process now. If you have a tablet, a phone, a piece of paper, or you're just going to mentally have reference points here, I want you to test yourself. So what kind of team do you have? Well, your assets have not been reviewed and evaluated. So this is that bad situation that continues. The team hasn't really looked at your assets together and evaluated it. What is the nature of the assets and how do the assets flow at death? And by the way, I don't want to forget about the incapacity planning part, which is so near and dear to my heart because I see what can be done in real life circumstances when someone is incapacitated and the proper incapacity planning is done. Does everyone know these assets? And does everyone know that there is tremendous flexibility, let's say, for the agents to step into the shoes of the person who's incapacitated and manage the assets for their benefit? And does the team understand that? Okay, it's a very fundamental understanding. Take care of the person, pay the bills of the person, pay the bills of the person's spouse, take care of any person who is dependent on that person. Another bad situation, the team doesn't know your family members and has not been a part of a meeting with the family. The team has not collaborated. They have not agreed on various aspects of the planning. Now, I said 15 or 20 minutes. What if this took an hour? It's a very, very solid hour. If that team is committed, they're going to have an agenda, they're going to work towards your best interests, and they're going to give you that assurance. And that's what I'm saying here. The bad part here is you would have no real assurance and no real assurance that the team is going to continue to collaborate. One of the things I want to say before it goes away, when you're thinking through these issues, some of you may not be aware that you can articulate in your estate planning documents who your advisors are. For example, if you have a particular financial advisor who you're very committed to, and I know many of you feel that way, you can include that person or that organization in your estate planning documents. And you can say that to whatever extent you want to articulate this, that they can continue to act as your advisors in the future for the future beneficiaries, that is your desire. So you can articulate those kinds of things in your planning documents. But the worst part about this scenario of either having no team, having a team that doesn't communicate, having a team that is not going to give assurance to you, is that you may not even be aware of these problems or dangers associated with these kinds of non-collaboration issues. You see, the problem with estate planning is we don't know some of these issues actually exist until we pass away. We don't know that certain issues exist until we become incapacitated. So that's why you, being so conscientious to be on this webinar, are not going to let this happen. You're going to have a plan that you're striving for perfection to make sure these kinds of random issues do not occur because you have been proactive in advance. Now, what do we really want from this advisory team? Again, this is a non-technical presentation. I apologize. This is substantive, but non-technical. You want to know, you want to have this real assurance that everything is going to be fine. That's a given. But you need to look under the hood. You need to have this educational knowledge of the documents, maybe not all the technical aspects of the documents or of the planning itself, but at least the assurance that everyone agrees that everything is the way it should be. You want to know that your children will be taken care of, your spouse will be taken care of in a very practical way. You want to know that your planning will work, actually work as you envision it to work in the planning documents. And you want to make sure they will be protected, whatever that protection means to you. This could be protected against probate in some people's minds, protected against estate tax, protected against unintentional inheritance tax because we didn't know that was going to apply. We want to make sure that the onerous tax provisions of the Secure Act are minimized if that is a goal of yours, because there are ways to do that. We want to make sure that spouses and children are protected from the claims of creditors, divorcing spouses, bankruptcy, new spouses. This is the kind of assurance that we want to make sure you have, and that's this ideal thing. We want to make sure that tax-related issues are handled. We mentioned that. We want to know that assets are sufficient to meet your family's future. None of us really knows how many assets we're going to have at our death. This is particularly true in special needs planning, where we're trying to provide for a special loved one who's got disabilities. But there could be other reasons why we want to make sure the assets will survive us in a sufficient way. And that's why our financial advisors and team will hopefully help you grow assets. But if you don't have the ability to grow assets, or you have limited assets, you might engage in life insurance planning. Life insurance is the Swiss Army knife of estate planning, we say, and you may use that as a wealth transfer tool or a wealth creation tool. So we want to make sure that you have this information and you're fully supported in your approach. And we want to know that your advisory team will work diligently in your family's best interest. And I can tell you that, again, I've seen some wonderful examples of this recently, where certain firms that we've dealt with, advisory firms, they are really stepping up their game to take care of clients. So what is the advisory team's strengths and weaknesses and challenges? Well, their strengths, they have collective knowledge. Can you imagine in your own fields, as many of you are professionals, you know what the scope of that professional knowledge is that you used in your life and career, or you're still using it. Well, imagine the collective knowledge of the lawyers, the CPAs, the financial advisors, the life insurance professionals. They have tremendous collective knowledge. They have collective resources, experience. They should be able to intuitively anticipate problems and solve problems, but they must have a willingness to do that. And most of them do. It's not always true. You want someone who's competent, you want a team that's competent, but you also want someone who is willing. I have worked again with lawyers who were tremendously intellectual and capable, but did not have the willingness to go the extra mile for clients. We want to make sure that your whole team is going the extra mile. They do generally, they meaning your advisory team generally does have this desire to achieve the highest levels of performance and service. We're living in a very competitive world. If for no other reason, these professionals want to succeed, they want to strive to outperform their competition, and that is in your best interest. For example, many advisory firms right now, financial advisory firms, are pricing their services in such a way that it's very advantageous for you, and they want to attain that high level of performance. But we want that on the personal level for you as well. They have a collective desire to perpetuate relationships with you, to obtain referral business and keep assets under management. This is all in your favor to be able to form a team that actually will work for you the way it should. And again, they want to accomplish their goal, their professional goals and legacies in delivering excellence to their clients. So that is a real good list of strengths for these people and this kind of team concept. But as I just mentioned, some of the challenges and weaknesses are, there could be a lack of willingness. There could be some professional issues, and I will just go out and say this, professional snobbery, or other issues where the team is just not willing to go the extra mile. I will say this is not the normal rule of thumb, but I have seen it, and it's just something for you to be aware of as you try to achieve perfection. Failure to recognize what you want. This is something where the advisor or lawyer could be engaging in something that I would just call paternalism. They are trying to set the goals for you instead of recognizing what your goals are. They are being driven by certain things that they've been trained on rather than listening to what your goals are. We don't want that. Failure to be imaginative and resolve issues. I find that this is where a lot of wonderful things can happen, where the collaborative team is creative. Failure to make their resources available. There are people out there who have tremendous resources, but they don't communicate that very well. I don't think it's intentional. I just think that's out there and we have to be aware of it. Fear of a breach of good faith and professional courtesy. There are people who are afraid to engage with a team. There are people who are more secretive in their practice, or they work in silos. We don't necessarily want that. That's not going to be part of a good advisory team. Failure to allocate appropriate resources, failure to understand the ramifications to clients for this failure of communication, and failure to verify. So one of the reasons to have a team that is not only communicating, but will meet with you and meet with your family together, is to make sure that things are verified. It's so easy today for something to slip through the cracks. So again, we're going to get there. We're going to get through that 240-mile race one way or the other. No matter how long it takes us, we're going to get there. But we just want to make sure that we're continuing to strive, because if we do, we will overcome most or all of these potential challenges. So the worst case scenario, as we start to go towards the end of the presentation, the worst case scenario is that you suffer, and this is what we're trying to avoid. The planning doesn't work as intended. Your intentions are thwarted. We want to make sure, obviously, that doesn't happen. Family conflict happens because things weren't the way they should be, or there were a lack of verification, lack of communication. There's unanticipated taxation. Now, this is something that can very much happen on a routine basis. Family conflict, taxation, at-risk beneficiaries are not protected properly. Hopefully this is not going to happen, but it can happen. Family resources that could have been preserved are compromised. I saw an example of this in the last couple of years, where assets were left down to a beneficiary, but they were incorrectly, the documents were incorrectly drafted, and it caused an estate tax. These things can happen. I saw a document incorrectly drafted that caused a huge income tax and a loss of step up in basis of the assets. So that is a loss of family resources. This is because there are no collaborative efforts, no eyes and ears looking at what's really going on. Flexibility is lost. So if there's no good planning in place, or planning doesn't work the way we want, flexibility could be lost. For example, someone who doesn't update their powers of attorney. Here we go again, talking about incapacity. Well, if someone has to have a guardianship instead of having the ability to rely on their own private documents, now we've lost flexibility, because there's very little flexibility inside of a guardianship, not to mention the loss of rights of the person. Long-term benefits are irretrievably lost, such as the long-term benefit of, let's say, tax deferral. When that estate tax was enacted on that particular plan I was mentioning, where that was incorrect drafting, now those assets are not only lost, but all the future appreciation and long-term benefits of those assets are lost. So the best case in this bad scenario is that luck or good fortune gets us through without any kind of injury to the assets or the family members. So that's kind of the best case, and that's kind of scary. In this world today, as we know, you are committed in being on this webinar this morning, we cannot rely on luck. So other goals or intentions are not achieved, and I think I've made my point here on this slide. So the worst case scenario is here, but you will definitely suffer. Your family members will suffer if this perfection or close to perfection is not attained through long effort. Now, again, we want to ensure that the advisory team is in place, and we must insist in the highest and best interest of you and as the client that this team collaborates together. You'll notice now I'm being very, very redundant in the last several slides. So this is how important I think this particular section of the presentation is to your achievement of perfection. You have the commitment. Let's say you seek out the law firm that participates with you and provides continuous updating, but the law and the documents and the scope of the law side of things is only one aspect of your planning. That's why I'm focusing on this entire advisory team approach, almost to the extent that it's being so redundant that it may be difficult to listen to. But I'm going to get through this, I promise, but you'll notice I'm putting a lot of emphasis on this. We want to ensure the advisory team is competent. We want to ensure communication. We want to see the scheduling of a team member meeting to ensure they know one another. You should insist on that. At that team member meeting, you should ensure that they review and evaluate your goals and understand the planning structure and the assets. We want to see that they have basically conceptually agreed on the scope of the planning, the structure, and that it makes sense to everyone involved, okay? There could be aspects that one hand doesn't know what the other is doing. We want to avoid all of that through your professionals collaborating with you and with your family. We want to know that your family members know who these people are, and we want to introduce them. We're setting the bar very high. We want to introduce them at a brief family meeting. And we want to engage and gauge, I should say, and ensure that you have, your spouse has, and that your family has the real emotional assurance that the team will continue to collaborate when you are no longer here. So the importance of partnership, whether it's with your financial advisor, your CPA, your attorney, and their partnership and their collaborative support of you. Knowledge is only potential power, okay? We have to have the application of the knowledge and the communication to have power. Documents are important, but they're only one aspect of the planning. That is a one-dimensional approach. We don't want that. We want a process approach. Attorneys must offer clients the ability to succeed and a path forward, not only providing legal technical knowledge that's superior, a willingness to apply that knowledge, a willingness to deliver a process that the client can participate in and believe in, education and care of the client and their family members and fiduciaries, and longevity of the professional firm, that there is a succession plan that the future beneficiaries can rely on, or a path for them to be able to get the support they need when you're no longer here. You must have the confidence in your attorney's ability to solve your problems and help you attain these goals, not just in a transaction, but in a long-term process, so that when you're going through that long race, that long uphill climb through the rest of life, where you're updating your planning all the time, you'll know that you have the support that others believe in the same thing that you're trying to achieve. So power in estate planning equals, as we start to wrap up, eliminating randomness and the lack of process through being intentional. Okay, we're being intentional. Eliminating a focus on documents, I just said that. Commitment on the part of you, a client, for example, or prospective client, to engage in the estate planning process as a life process and not a transaction. Commitment on the part of attorneys and other collaborative team members to provide you with the ability to succeed. Process, there has to be a process before the planning starts. There has to be a process during the planning. There has to be a process after planning. This uphill climb takes process all the way through to the end. Client care program, very, very key to giving you a path forward, to continuous updating, legal education, and staying abreast of change in this world today. So I'm looking at my clock and it looks like we're pretty much on time. I'm about 5 minutes early, but we're going to start to wrap up, and I thank you for your time and attention. I know that was pretty intense, especially about the collaborative team. So again, if I could be of any value here this morning to give you something of substance to walk away with, I would say challenge yourself to start the process of planning to achieve this perfection, not with perfection as an obstacle, but perfection as a goal through continuous effort, okay? And for those of you who already have planning, it's a good time to review all existing planning documents. Now, as you see here in my bullet points on this next to last slide, Elville and Associates generally does not charge to review your existing documents, so please allow us to do that. We're happy to do that. Set a consultation with us. There's nothing to fear, because even though you're sharing personal information, that information is a client confidentiality-based relationship with us. Everything is confidential. It's an attorney-client relationship. Even if you do not become a client of our firm or any other law firm, that consultation is privileged and the information is private and confidential. We want you to relax. We want you to bring your existing documents. We want you to talk about your advisory team. We want to get to know them. We want to help you form a team if you don't have one, or replace a team that you feel may not be serving you well, and hopefully that's not the case. We want you to bring lots of questions. We love questions. We are here to answer your questions. Perhaps in all of this, the best thing that we can do for anyone is to give them a place and a time to think through very, very important issues in their lives, and to have epiphanies and have the open partnership discussion about paths forward so that you have the time to think when otherwise our lives are so busy and we do not have the time to think about some of these important concepts. So on a December 8th Friday, and only a few weeks before Christmas, I thank you for your time and attention. Thank you for sitting through this on a Friday morning. I wish you the best today and over the weekend and in the holidays. And Jeff, I'm going to turn it back to you.
Well, thank you, Steve. I wish we could actually just end on your thoughts, but I'm going to say a few things, I guess, as we wrap up here. Now would be your time to get any final questions into Steve. I've always found that this presentation doesn't really yield a lot of questions. It's more of I think it's a fitting end to our webinar series for the year, aside from our guest presenter on Tuesday, which will be a wonderful presentation. It's a time to kind of reflect and yields more internal thought and reflection on where you are in your estate planning and your process. And we certainly get follow-up afterwards, but I think this is certainly, among all the dozens and dozens and dozens of presentations we've offered this year, a very fitting discussion and presentation by you, Steve. So thank you very much, and thanks to all of our attendees for being here. So, but any questions certainly are very welcome. So as always, I'll be sending out today's video and some other resources to you for your perusal afterwards. On Tuesday, we'll be bringing back our wellness series with Dr. Michelle Fritsch, Thriving Through the Holidays, a celebration of gratitude. Really looking forward to that presentation. And that will end our webinar series for the year. And it will be back and better than ever in 2024. And we'll start off with none other than our Essentials of Estate Planning and Elder Law on Wednesday, January 3rd, with none other than Stephen Elville. Want to really thank you for your support of our Elville webinar series and relationship with our firm just in general. We always got a great team here. We work really, really hard throughout the year taking care of clients, from led by Steve, our other attorneys, our paralegals, our billing department, myself. We just want to thank you. You have a lot of choices, and being here today and your relationship with the firm really means a lot. And if you have anything that we can do for you now or in the future, for yourself or a family member or a friend or a colleague, you know where to turn. Here at Elville and Associates, we'll take care of you. So with that said, looking forward to seeing you again soon. And thank you for being part of the Elville webinar series and Elville and Associates. Have a great day and a great Friday, and we'll see you again soon.
Thank you.